Hello and welcome to the e-Pathshala course on intellectual property rights. I am Yogesh Pai, Assistant Professor of Law at National Law University, Delhi. We are going to discuss today a module on plant variety protection and farmers' rights. In the context of plant variety protection, we have the following learning objectives: to understand the need in the context of plant variety protection in India, to understand the nature of international regime concerning plant variety protection, to understand the importance of farmers' rights in the context of plant variety protection, to understand the nature and requirements of registration concerning plant variety protection, to understand how courts have evaluated the criteria of plant variety protection, to understand the concept of gene fund, a national gene fund in the Plant Variety Protection Act 2001, to understand the nature of rights, infringement and remedies in the context of plant variety protection, to understand the various limitations and exceptions that are present in the Plant Variety Protection Act 2001 in India. One of the first things that we need to discuss in the context of plant variety protection is the need and the context for plant variety protection. The need for plant variety protection arises because there is some level of protection that is absolutely necessary to provide incentives for plant breeding activities. Modern plant breeding activities is an investment driven activity. Modern plant breeding techniques are greatly influenced by the outcomes of biotechnology, and hence India enacted the Plant Variety Protection and Farmers' Rights Act 2001. India enacted the Plant Variety Protection Act and Farmers' Rights Act 2001 also in the context of the mandate and requirement in the TRIPS agreement. Article 27.3b of the TRIPS agreement says that members may exclude plants from patentability, but it requires protection for plant varieties in the form of an effective sui generis system or through patents or through a combination of both. Now, India has chosen to enact a sui generis legislation on plant variety protection through the Plant Variety Protection and Farmers' Rights Act 2001. It is also important to understand in the context of international protection that Article 27.3b of the TRIPS agreement does not require countries to comply with the UPOV convention, that is the International Union for Protection of New Varieties of Plants, either the 1961 or the revised version of 1991. Now, both the versions could be subscribed by India, but in case of 1978 the subscription is closed and it is open for India to subscribe to the 1991 version. Now, the 1991 version looks into the principle of national treatment, minimum standards of protection, right to priority and breeders' rights, etc. So, the objectives of plant variety protection under the Indian Act are to stimulate investment for research and development both in the public and the private sector for development of new varieties by ensuring appropriate returns on investment, to facilitate the growth of seed industry in the country through domestic and foreign investment which will ensure the availability of high quality seeds and plant material for Indian farmers, and third, to recognize the role of farmers as cultivators and conservers and the contribution of traditional, rural and tribal communities to the country's agrobiodiversity by rewarding them for their contribution through benefit sharing and protecting the traditional right of farmers. With these three objectives in mind, let us now discuss the differences between the international regime, that is the UPOV 1978 and 1991 regime. In terms of the minimum coverage, UPOV 1978 Act requires protection from 5 years at the time of accession to 8 years to 8 years later. In case of UPOV 1991, increasing number of genera or species required to be protected from 15 at the time of accession to all genera and species to 10 years later. 5 member states of the earlier UPOV Act have those who have considered with the 1978 Act. Eligibility requirements, novelty, distinctiveness, uniformity and stability, they remain the same in case of 1991 Act. In case of minimum exclusive rights in propagating material, production for the purposes of commercial marketing, offering for sale, marketing, repeated use for the commercial production of another variety. In 1991 Act, production or reproduction conditioning for the purposes of propagation, offering for sale or selling or other marketing, exporting, importing or stocking for any of these purposes. Minimum exclusive rights in harvested material, no such obligation except for ornamental plants used for commercial propagating purposes. Same acts in case of 1991 if the harvested material obtained through authorized use of propagating material if the breeder has no reasonable opportunity to exercise his or her right in relation to the propagating material. In case of prohibition on dual protection with patent, 1978 Act specifically requires that there must be no dual protection for botanical genus or species. In case of 1991 Act, there is no such requirement. The breeder's exemption is mandatory in case of the 1978 Act, where the breeders are free to use protected variety to develop a new variety. In case of 1991 Act, it is permissive, but breeding and exploitation of new variety essentially derived from the earlier variety requires right holders authorization. In case of 1991 Act, the farmer's privilege implicitly allowed under the definition of minimum exclusive rights. In case of the 1991 Act, the farmer's privilege allowed at the option of the member state within reasonable limits and subject to safeguarding the legitimate interests of the right holder. Minimum term of protection 18 years for grapevines and trees, 15 years for all other plants, 25 years for grapevines and trees, 20 years for all other plants. The types of varieties that are open for registration under the PVPFR Act are novel varieties, extant varieties, farmers varieties and essentially derived varieties. An extant variety means a variety A that is notified under section 5 of the Seeds Act 1966, a farmers variety or a variety about which there is common knowledge, or any other variety which is in public domain. A farmers variety under the Act means a variety which has been traditionally cultivated and evolved by the farmers in their fields, or is a wild relative of the land race of a variety about which the farmer possesses common knowledge, where farmer means any person who A cultivates crops by cultivating the land himself, or cultivates crops directly by supervising and cultivation of land through any other person, or conserves and preserves severally or jointly any person, any wild species or traditional varieties, or adds value to such wild species or traditional varieties through selection and identification of useful properties. Essentially derived variety is a variety which is predominantly derived from another variety, protected or otherwise, and conforms to the initial variety in all aspects except for differences which result from the act of derivation, which is, and yet it is clearly distinguishable from the initial variety. Now, the Act requires that any of these varieties are required to be novel, distinct, uniform and stable. So, what are these characteristics regarding novel, distinct, uniformity and stability? Novelty in plant variety protection would mean, or would be based on the commercial exploitation A in India earlier, not earlier than 1 year, or outside India in the case of trees and vines, then 6 years in other cases, earlier than 4 years before the date of filing of such application. However, the trial and use does not destroy the novelty, and disclosure in common knowledge other than the above does not result in destruction of novelty. The distinct characteristic required by the plant variety for the purpose of registration, Plant Variety Act for the purpose of registration, is that it shall be clearly distinguishable by at least one essential characteristic from any other variety whose existence is a matter of common knowledge in any country at the time of filing of the application. Uniform if subject to the variation that may be expected from the particular features of propagation, it sufficiently stays uniform in its essential characteristics. Hence, distinctiveness and uniformity are two different criteria. Stability is another criteria, which is if its essential characteristics, it remains unchanged after repeated propagation, or in the case of a particular cycle of propagation at the end of such cycle. Now, apart from these conditions for registration, there are certain conditions that any owner of plant variety protection must follow. He must mention the denomination. Every applicant shall assign a single and distinct denomination to a variety with respect to which he is seeking registration. No registration of a variety shall be made under the Act in cases where the prevention of commercial exploitation of such variety is necessary to protect public order or public morality or human, animal or plant life and health, or to avoid serious prejudice to the environment. This is one of the most general clauses that relate to public order and morality, through which no registration can be entertained. It means the plant variety protection, the plant variety authority has absolute powers in relation to rejecting certain registration based on this condition. Furthermore, terminator technology are not allowed to be registered. The Act says that no variety or any genera or species which involves any technology which is injurious to the life or health of human beings, animals or plants shall not be registered under this Act. Explanation for the purposes of this section is provided, wherein any technology includes genetic use restriction technology and terminator technology. There are certain farmers' rights as per the Act. Now, the Indian Act is unique because apart from the rights that are granted to breeders, there are certain rights that are inherent to the farmers and that have been specifically granted under this Act. A farmer who has bred or developed a new variety shall be entitled for registration and other protection in a like manner as the breeder of the variety under this Act. A farmer who is engaged in conservation and use of genetic resources and wild relatives of economic plants and the improvements through selection and preservation shall be entitled to a recognition and reward from the government, provided the materials so selected and preserved has been used as donors of genes in varieties registrable under this Act. The farmers shall also be entitled to save, use, sow or resow, exchange, share or sell his farm produce including seed of a variety protected under this Act, provided it does not apply to branded seeds. And branded seeds mean any seed put in a package or any container and labeled in a manner which gives an indication that such seed is of a variety produced or protected under this Act. The number of registration and applications received under the Act, we have a descriptive analysis of it. Until August 2015, there were 1,424 public applications. Private parties have made 2,954 applications. Farmers, which form the majority of the applications, have made 5,693, and individuals have made 2 applications. The total number of certificates issued by the Plant Variety Protection Authority is 1,870 until August 2015. These are the most recent statistics available in this regard. Benefit sharing under the Plant Variety Protection Act is one of the important pillars of the legislation. Benefit sharing, however, is only for Indian citizens and organizations. Breeders can oppose the claims regarding benefit sharing. The Plant Variety Protection Authority shall decide the quantum of benefit sharing. The amount of benefit sharing will be deposited in the National Gene Fund. The importance of having a benefit sharing requirement under the Plant Variety Protection Act is precisely because certain varieties have been traditionally cultivated, and the breeders who rely on such varieties are required to make payments regarding the benefits that they have derived from using those varieties for further breeding. Now, there is a very recent case that exposes how the breeders have sought to evergreen the protection available under this Act. In Maharashtra Seed Corporation, Monsanto and others versus Union of India, the Delhi High Court in January 2015 had a very important question to answer. The question was, if hybrid variety already registered and whether parental lines involving those, whether they can be registered under the Act as a new variety. The Delhi High Court denied registration of parental lines based on the argument that such a registration would allow extension of protection, overall protection available for the variety. The Delhi High Court said, if the provisions of section 15(3) of the Act are read in a manner as suggested by the petitioners, that is Maharashtra Seed Corporation, the effect would be to extend the period of protection many times over. In the first instance, a breeder would get protection in respect of hybrid variety, and assuming that there are two parent lines, the breeder could just before the expiry of registration certificate in respect of a hybrid variety register one of the parent variety and thus extend its period of exclusivity for a further period of 15 to 18 years, because protection of even one parental line would practically ensure exclusive rights in relation to the hybrid variety. In the same manner, before the expiry of the registration period of the parental line, the breeder could register the other parental line as a new variety. In this manner, a breeder could extend protection for a period up to maximum of 45 to 54 years instead of 15 to 18 years as contemplated under this act. Clearly, this is not the legislative intent of the parliament. It seems the reasoning behind this decision is that the court was trying to avoid overlapping of protection by virtue of seeking continuous protection on parental lines before the expiry of protection for existing varieties, which the court said was not possible under the act. There are certain rights, there are questions relating to how to determine infringement, and there are remedies available under the act. The rights granted under the act are to produce the exclusive rights to produce the protected variety, the exclusive right to market and sell the variety, the exclusive right to distribute the variety, and the exclusive right to import and export the variety. Now, in case of essentially derived varieties, where the essentially derived variety from a protected variety, then authorization required from the breeder of the initial variety. So, hence the right is subject to, in case of essentially derived variety, is subject to the authorization from the breeder of the initial variety. Infringement amounts to, as per the act, any act of selling, exports, imports or export of a registered variety, or sells, exports, imports or exports a variety deceptively similar to the registered variety. The relief that is granted under the act is injunction, and then you have an option of either accounts for profit, that is sharing of the profits, or damages. Finally, there are certain exceptions and limitations granted under this act. The acts that are not to be considered as infringement primarily deal with the rights of the researchers. Now, in case of researchers' rights, the use of a variety for research and experimental purpose is perfectly allowed, which means that these acts shall not amount to infringement. Secondly, the use of a variety as an initial variety for the creation of a new variety is absolutely allowed. The repeated use of a variety for commercial production of a new variety is, however, not allowed without authorization of the breeder of the registered variety. There are provisions concerning compulsory licenses, which is available 3 years after the grant of the protection, that is after issuance of the certificate, on account of unaffordable pricing and unmet demand. To summarize, let us briefly recapitulate what we have done through the whole module. We have looked into the objectives of the Plant Variety Protection and Farmers' Rights Act 2001 in India. Among the important objectives is to incentivize the creation of new plant varieties and to incentivize production of seeds in the country. We have looked into the international regime for protection, primarily the TRIPS agreement requirements under Article 27.3, and also the Union for Protection of Plant Varieties, to which India is not a party to. We have discussed the differences between the 1978 and the 1991 regimes of UPOV. We have also looked into the requirements of registration in India, which is novelty, distinct, uniformity and stability. We have also looked into how and what kind of varieties are acceptable under the act, that is the requirement, those varieties which are novel, which are extant varieties, which are farmers varieties, and which are essentially derived varieties. We have also looked into the nature of applications made by different breeders, private, public, individuals and institutions. We have looked into the requirement of benefit sharing under the act and how benefit sharing is to be done, and adequate amount of benefit sharing has to be made by the authorities, the quantum to be decided by the authorities under the act. We have looked into the issues of infringement remedies under the act and how infringement is defined and what rights are granted. There are also certain limitations and exceptions granted under the Act precisely for researchers, and also provisions concerning compulsory licenses. Most importantly, one of the fundamental pillars of the Act is the farmers' rights that are provided, wherein the most important of such rights is the farmer's right to save, resow the seeds for further production, except where the seeds are branded. So overall, the Plant Variety Protection and Farmers' Rights Act is aiming to balance the incentives for the breeder with the traditional rights that farmers have in relation to their plant varieties. Thank you one and all.